Thank you, Mr. President, for those kind words. Members of the bench, members of the bar, members of the Academy, it is indeed a great honor to be here at the 6th Biennial Conference on the Law of Obligations. To me, a conference every 2 years on the law of obligations, bringing players from the various continents who share so much common law in this area, is a very important and significant event. And I am very proud, along with the university, that we are able to host this event in Canada this year. A conference such as this makes an enormous contribution to both private law and its subset, the law of obligations, which are very vitally important to our society. And as you've heard, from the beginning of my legal career, and we're not talking about the end yet, but so far, one of the things that has given me, that I have found the most interesting and indeed has given me the most satisfaction as a jurist, is wrestling with the problems of private international law. Why has this given so much satisfaction? Because this is quite simply a very important and significant area of the law, fundamental to what we call the rule of law in our societies. When we speak of the law of private obligations, we speak of a body of law that is a pervasive phenomenon in social life. To quote, a silent and ubiquitous participant in our most common transactions. Those words, spoken by University of Toronto professor Ernest Weinrib, were amplified as follows by the professor. He said of this branch of the law, it regulates the property we own and use, the injuries we inflict or are afflicting, the contracts we make or break. It is the public repository of our most deeply embedded intuitions about justice and personal responsibility. Private law is also among the first subjects that prospective lawyers study. Its position in law school curricula indicates the consensus of law teachers that private law is the most elementary manifestation of law. Its reasoning paradigmatic of legal thinking, and its concepts presupposed in more complex forms of legal organization. End of quote. Its wide impact on society is not only the result of the conceptual nature of the law of private obligations, but the mission and breadth of that branch of the law. William Blackstone introduced readers of the commentaries on the laws of England so long ago to the area of private law with these words: the more effectually to accomplish the redress of private injuries, courts of justice are instituted in every civilized society in order to protect the weak from the insults of the stronger, by expounding and enforcing those laws, by which rights are defined and wrongs are prohibited. That is what we are all about, protecting the weak from the insults of the stronger, expounding and enforcing the laws that define basic rights and prohibit wrongs. And nothing can be more important to the rule of law. And Blackstone, by inference, also acknowledged the breadth of the subject. He didn't offer a definition, and we aren't very good at that, perhaps, in the law. Professor Stephen Wadhams, whom I believe is on the program, has noted, and I quote, Anglo-American laws claim many merits, but linguistic and conceptual precision are not among them. Private law, as the term has evolved, refers simply to the entire gamut of mutual rights and obligations of individuals. Everything but what it excludes, being public international law, constitutional law, municipal law, administrative law, criminal law, military law, and taxation. A vast field indeed. But not only is private law important, broad, and pervasive, it is ever-changing. New laws, new techniques, new disputes, and occasionally new judicial decisions, more of which later, are constantly transforming the landscape. Le droit privé est non seulement un domaine très vaste, il est également un domaine en constante mutation. When Lord Sankey developed the living tree doctrine in 1930 and declared that the British North America Act of Canada planted in Canada a living tree capable of growth and expansion within natural limits, he was talking about the constitutional law. But all areas of law, private law included, are living, constantly evolving trees. Some branches sprout and grow, others crack and need trimming. It is in this manner that the law develops, adapts, and remains responsive to changes in society. The society in which we are living is changing faster than ever before. To be sure, lawyers, academics, and courts continue to wrestle with modulations on old problems within the law of obligations. The elements of contract obligation, the conditions that create duties of care and negligence, the just scope of damages, the proper ambit of unjust enrichment, all of which you will be discussing in the days to come. And that is essential. But the increased rate of social change that we are experiencing is requiring us not only to seek better solutions to the old problems, but to constantly seek solutions to new problems, or old problems presented in new forms with new ramifications. To cope with these new problems, the living tree of obligations must sprout new branches, put forward new leaves, produce new fruit, or it will at an unprecedented rate. Will the fruit be sustainable and good, or will it be crabbed, destined at best to wither on the tree, or at worst to sicken and slow the legal system and society's expectation of justice? Or indeed, as I will get to toward the end of my talk, will the tree continue to produce fruit at all? Let me briefly illustrate what President Chakra has already mentioned, some of the seminal cases that we have been dealing with in private law recently. And this is only a sampling. And this is in the last couple of years. The tort requirement of causation in light of increasingly sophisticated scientific modeling of accidents. The ambit of motor vehicle liability under government-regulated schemes, should the courts take a broad or narrow approach. A case just released a few weeks ago. The liability of state regulators like mortgage regulators or stock market regulators to individuals, the Cooper line of cases. The liability of governments for health policy, Imperial Tobacco. Defamation in the age of the internet, the Grant case. The interface between private obligation and criminal responsibility, which is before us now in cases on whether HIV-positive individuals must disclose their condition to prospective sexual partners. Some of these changes have produced new legal problems are the result of scientific developments. Some flow from the communications revolution. Others are the result of the government response to complex legal problems, old and new. Whatever the source of cases such as those I've just mentioned, it seems clear to me from my perch on the nation's final tribunal that the justice system will increasingly be confronted by new problems in the law of obligations, private obligations, and at an unprecedented rate. The common law, and in Quebec the civil code, have laid a firm foundation upon which to build in meeting the challenges that the law of obligations will face in the future. To return to the metaphor of the living tree, that tree, the tree of private obligation, stands at the moment tall and strong. Indeed, its strength is a major asset in the increasingly competitive world quest for investment and growth. Study after study shows that a coherent private law framework and an independent judiciary are critical both for economic development and social cohesion. It falls to us, the jurists, litigators, and academics of today and tomorrow, to ensure that the legal system will continue to provide just and practical solutions to the problems society will assuredly throw our way in the years to come. How can we do this? In the time that remains, I would like to suggest 3 things that are essential to maintaining a just and effective law of obligations, now and for the future. The first is a solid grounding in principle and theory. The second is a flexible, open approach grounded in the needs of society. And the third is continued access to a court-based process. I will discuss each in turn. The first is a solid grounding in principle and theory. On this first essential of a just and effective law of private obligations, I suspect that I am preaching in this room to the converted. Your presence here today and the fascinating roster of subjects on your program attest to your belief in the imperative of the importance of solid foundation for the law of obligations in principle and coherent legal theory. No matter how new the problem may seem, solutions must be rooted in the principles and theory of the past and the present, if they are to be appropriate and to endure. The solutions of the future must cohere with the principles of the past to form a unified whole. This is not to say that major shifts in the law are unthinkable. Occasionally, as with the seminal principle of negligence laid down in Donahue and Stevenson, a radical rethinking of the law may be required. Occasionally, realignment may be appropriate. An example is the introduction of the defense to a defamation claim of responsible journalism, which our court made in Grant versus Toronto Star recently. But even radical changes and realignments must be tied to the general theory that animates the particular branch of the law of obligation at issue. Policy is everywhere and always at work in the law of obligations, sometimes unacknowledged, more often in our modern tradition, openly discussed. But policy, as Master of the Rolls McGarry warned so long ago, may be an unruly horse. What tames the unruly horse? What guides it and keeps it in check are principle and theory. Guided, thus, the horse of policy, instead of running amok, follows a coherent path and finds a solid bridge that conveys the law from the past through the present and into the future. Second, a flexible, open approach grounded in the needs of society. The second thing I believe to be essential if we are to maintain a just and effective law of obligations is keeping the law current and relevant to the needs of society. The law is an institution whose sole purpose is to serve society. It does not exist to provide work for lawyers or to furnish interesting problems for academics and judges to consider and solve. It exists to provide a predictable framework for conduct to the public at large and to resolve legal disputes when they arise. To do this, the law must stay current. It cannot content itself with analyzing the problems of the past, as important as that may be. It must look to the present and beyond that to the future. And it must be practical and pragmatic. I have learned as a judge that it is not enough to study the principles and the texts and produce an elegant, or so I like to think, solution. The judge must strive for a solution that will work on the ground, that can be applied in a way that produces a just result. Our world is complex and, it must be said yet again, ever-changing. Keeping the law current and relevant is a challenge in such a world. But if we care about the rule of law, it is a challenge that we must meet. This brings me to the third condition of a just and effective law of obligation: that the court system continue to be involved in the development of the law. We who revel in the world of private obligation tend to take this for granted. After all, are not the law of torts, the law of contract, the law of unjust enrichment, and I could go on, the products of common law courts? And in Quebec, have not judges played a large role in developing la doctrine that governs private obligations? But we should not take it for granted. Increasingly, cases are not coming to court. The trend is clear. Fewer and fewer private law cases are reaching the courts where the law is developed. Instead of being resolved by judges, disputes are being resolved through mediation, arbitration, and other forms of alternate dispute resolution, known collectively as ADR. With only mild hyperbole, University of Wisconsin law professor Mark Galanter, speaking of litigation generally, describes the development of what he calls the vanishing trial. This trend is particularly apparent in private law. While private law disputes are abundant and lawsuits not uncommon, it is increasingly rare for them to go to trial. How widespread is this phenomenon? Statistics from the United States reveal that federal courts had tried fewer cases in 2002 than they had in 1962, despite a five-fold increase in the number of civil cases instituted. In state courts, the same trend was playing out. The number of civil trials fell 40% from 76 to 2004. Massachusetts Chief Judge William Young effectively encapsulated the problem in an open letter to the United States District Judges by writing, and I quote, "The American justice system is withering away. This is the most profound change in our jurisprudence in the history of the Republic," end of quote. In Canada, the term vanishing trial may not be used as often as in the United States. Nonetheless, recent statistics demonstrate that the phenomenon has undoubtedly extended north of the Canadian border. Data from the Ontario Superior Court of Justice shows that between 1998 and 2003, civil trials fell by 42%, and the tale is the same in other parts of the country. A Canadian commercial litigator, David Elliott, has opined that, and I quote, "The vanishing trial concept is certainly the case here." In the United Kingdom, the decline is even more dramatic. Since 1983, according to the statistics I was able to get, the number of trials steadily dropped, reaching 698, a decrease of almost 80%. And there are academics in England who say that private obligation trials are now a rare thing, except in the case of large corporations, multi-moneyed disputes. Why are fewer private law cases coming to the courts? Numerous reasons for the phenomenon of the vanishing trial have been proposed. Some suggest that societies become less litigious. Others discount this idea since the total number of case filings seems to be up. The Honourable Warren Winkler, the Chief Justice of Ontario, blames the general decline in litigation on cost and delay. He has said this: "First, our civil justice system often fails to meet the needs of ordinary Ontarians who require at once the fair, timely, and affordable resolution of their legal problems. Second, an increasing number of litigants are transferring their cases from traditional justice into private arbitration. That is, trials are vanishing for two distinct reasons, but related reasons. Ordinary litigants simply can't afford to take their cases, and well-heeled litigants are heading for the exits." In truth, there are many reasons why litigants who in another era might have taken their private obligation disputes to courts now turn to ADR. ADR promises dispute resolution without costly delay, as Chief Justice Winkler notes. Commercial actors want to get the job done and move on. Setting the law on an arcane issue is far down on their list of priorities, if it figures at all. Related to the speed with which the dispute is resolved is the additional flexibility arbitration offers. Arbitrators are more sensitive, it is said, to scheduling needs of parties than our courts. ADR may also be better at preserving business relationships between parties. The adversarial system of litigation, if not carefully managed, can lead to acrimony that impairs future dealings. ADR, it is said, allows parties to choose specialized adjudicators with specific training and experience. Pick your judge. They are confident, clients are confident, these judges may better understand their problems. ADR permits the utilization of creative solutions that the all-or-nothing nature of litigation precludes. ADR offers finality. Don't have to worry about courts of appeal, much less the Supreme Court of Canada. ADR allows parties to resolve their disputes in a confidential setting. When parties reject litigation in favor of ADR, they do so to avoid, sometimes, the openness of the courts, the openness that we as lawyers and academics prize, but clients, individuals may shun. As one counsel has recently opined, and I quote, "The biggest benefit of arbitration is that it's non-public." And finally, underlying all the above reasons is the issue of cost. The quicker parties can resolve their conflict and move on, the lower the overall cost. Given these advantages, we should not be surprised that ADR has garnered a loyal following, nor that 97% of corporate executives recently said they favor ADR over litigation. Private law litigants, for a host of complex and intertwined reasons, are increasingly eschewing the road to the courthouse and relying on ADR, with and without the concurrence of the courts. ADR is here to stay, and in many ways that is a good thing. However, the Vanishing trial does present a challenge to the continued development of the law of private obligations. Professor David Lubin has catalogued a variety of public goods that the court system produces, taking cases through the court system produces, including opportunities for intervention by persons not party to lawsuits, discovery, publication of important facts, structural transformation of public and private institutions. Trials also satisfy the public interest by providing checks on power of commercial actors and catharsis in dealing with events of public importance, and more generally, simply by demonstrating that the justice system works. But most critically for our purposes today, resolution of private law disputes through courts promotes, indeed, is perhaps the only way of promoting the development of the common law in this area. Court decisions over the years build up a legal framework against which private law disputes, contracts, tort, and more can be judged in whatever the forum, including ADR. So it's imperative, in my view, that the courts continue to play an important role continue their historic role in providing the legal framework that is necessary, quite simply, for the law to operate. Again, I quote Chief Justice Winkler, who said, "The common law's greatest single strength is its ability to transform itself organically and to respond to changing social, economic, and political values. However, it can evolve only if cases, including challenging and important cases, are being decided and appeals are being taken. If there are significantly fewer trials, the common law will stagnate and fail to develop with our society. Thus, the common law risks becoming antiquated and irrelevant." End of quote. So even in a world dominated by ADR, and I believe ADR is here to stay, the courts remain essential. They and they alone can discharge the task of developing the private law of obligations. When a case is resolved through ADR, it reflects terms that are mutually agreeable to the parties, but those terms are not available to the law or to the public. Instead of reasoned, transparent law, we are left, provided the settlement is not secret, which it often is, with little more than the announcement of how much money changed hands. And often, even that is kept secret. The living tree of the law finds little nourishment in such arid soil. The age-old fruits of the law, helping people predict the probable outcomes of their actions and modify their behavior intelligently, do not grow. As Lubin says, a world without adjudication would be a world without court-generated rules and legal precedents, without the shadow of the law in which the parties could bargain. It would be a world of atrophied advocacy and judicial skills, eroding accuracy in case assessment and diminishing judicial authority other than the final authority of commands backed by threats. In a world suffused with such legal uncertainty, disputing parties' assessments of both the merit and magnitude of their case would correspond only coincidentally. As a result, arriving at mutually agreeable settlements would be more difficult. To conclude, the third and perhaps most difficult task we face if we wish to maintain a just and effective law of private obligations is to maintain a significant role for the courts in the development of the law. We must ensure that the difficult questions that our rapidly changing world will inevitably throw up continue to be litigated in the courts with open arguments and reasoned decisions. Only thus can the process that has produced the rich resource of principle and theory and doctrine that has served us so well in the past continue. How can we do this? The response would be the subject of several more lectures and is under current discussion in numerous fora in our country. We must achieve it, however we go about it. We must ensure that the court process is a viable alternative to other methods of dispute resolution. We must be proposed to reform our procedures, to shorten trials, reduce costs, provide expert judges where necessary. The legal profession and the courts have begun, as I have said, to tackle this issue, but much remains to be done. Let me conclude these remarks. A just and effective law of private obligations is one of the pillars upon which the rule of law and a just and productive society rest. Maintaining a just and effective law of private obligations in our rapidly changing and complex world is increasingly challenging. To succeed, we must ensure that the law of obligations remains anchored in principle. We must ensure that it tackles the problems society throws up in a relevant and useful way. And we must maintain a role for the courts, the role the courts have traditionally played in the development of the law in this vital area. Your exchanges in the days to come will contribute greatly to these endeavors. I wish you every success. Merci beaucoup.